Hello, and welcome to this week's episode of the Illinois Appellate Roundup, where we tackle recent Illinois Appellate and Supreme Court decisions that represent important developments in appellate and post-conviction law. Whether you practice in this area yourself, or you or a loved one is facing an appeal or a post-conviction matter, I break these decisions down in plain English, what the court decided and what it could mean for you. This week, we stay at the very front of a criminal case, in the days before any trial, where Illinois' Pretrial Fairness Act now decides who waits for trial at home and who waits in custody. Our first case asks whether the state can revoke a person's release based on a new arrest in another state. Our second asks what a defendant must file before an appeals court will even look at a detention order. And our third asks what, exactly, that filing puts back in front of the judge. For each case, I'll give you the holding, stated plainly, and the takeaway for your own practice. Let's begin with the state's power to take release away. Our first case comes from the 4th District. A man named Ford had been released before trial. While on release, he picked up new criminal charges. Not in Illinois, but across the river in Iowa. The state moved to revoke his release and hold him, pointing to those Iowa charges. The trial court refused to consider them. Its reasoning was simple. The new law, it thought, only reached new offenses committed in Illinois, so charges from another state could not count. Here is what the 4th District held. It reversed. When the legislature rewrote the pretrial release statute as part of the Pretrial Fairness Act, it did not write in any limit confining revocation to Illinois offenses. In fact, an earlier version of the law had contained broader language about offenses in any jurisdiction, and that language was dropped in the overhaul. But dropping it did not shrink the statute to Illinois alone. It simply left the text without any geographic limit at all. So a new criminal offense that supports revocation can arise anywhere, including another state. The trial court had made an error of law by rejecting the Iowa charges out of hand, and the case went back for a proper revocation hearing, including the separate question the statute still requires, whether any conditions of release could protect the community. And here's the takeaway. If you represent someone who is out on pretrial release, understand that a new arrest anywhere, not just in Illinois, can be the basis for the state to seek revocation and return your client to custody. The geography of the new charge is not a shield. Counsel the client accordingly, and if you are litigating a revocation, focus your fight where the statute still leaves room, on whether the state can prove that no set of conditions would do. Our second case moves from the power to revoke to the gate a defendant must pass through to challenge a detention order at all. It comes from the 1st District. A young man named Talbert, 20 years old, was charged with serious offenses: armed vehicular hijacking and armed robbery. The trial court ordered him detained before trial. He wanted to appeal that order. But under the rules that govern these detention appeals, a defendant cannot simply go straight to the appellate court. First, he must file what the rule calls a motion for relief in the trial court, laying out why the detention decision was wrong. The state argued that Talbert's motion fell short, that it did not do enough to preserve his arguments, and that the appeal should therefore fail at the threshold. Here is what the 1st District held. On that threshold question, it sided with the defendant. His motion for relief was sufficient. The rule does not demand a polished brief or a catalog of every argument. It asks the defendant to identify the relief he seeks and the basis for it, enough to give the trial court a fair chance to correct itself. Talbert's motion cleared that bar, but clearing the gate is not the same as winning. Turning to the merits, the court held that the trial judge had not erred in ordering detention. Given the nature of the charges and the record before it, the decision to detain was sound. So the court affirmed, and here is the takeaway. 2 lessons live inside this case. First, the motion for relief that opens the door to a detention appeal does not have to be elaborate. A clear statement of what you want and why will ordinarily preserve your client's claims. So do not let the fear of imperfection keep you from filing. But second, do not mistake the gate for the destination. Satisfying the prerequisite gets you reviewed. It does not, by itself, unsettle a detention order the record otherwise supports. Win the threshold, yes, but build your real argument for the merits. Our third case sharpens the very question the second one raised. When a defendant files that motion for relief, What is the judge supposed to decide? It comes again from the first district. A man named Davis had been ordered detained. He was a convicted felon, and he had been found with a concealed handgun fitted with an extended magazine against a background that included prior weapons and child endangerment convictions. He filed his motion for relief, but the circuit court, in ruling on it, asked itself the wrong question. It treated the motion as if it were asking whether Davis's continued detention was still necessary now, as a fresh look at the present, rather than reviewing whether the state had carried its original burden to justify detention in the first place. Here is what the first district held. It agreed that the circuit court had framed the inquiry incorrectly. A motion for relief is not a request to reassess whether detention remains necessary as time passes. It is a challenge to the original finding, a test of whether the state proved, when it mattered, that detention was justified. So the trial court's approach was an error. But the error was not fatal, and here is why. On this kind of order, the appellate court can review the record itself. And when it did, it found that the state had established, by clear and convincing evidence, what the law requires, that Davis posed a real threat, and that no conditions of release could mitigate that threat. Because the record independently supported detention, the mistake below did not change the outcome, the court affirmed. And here is the takeaway. Know exactly what a motion for relief is asking a court to do. It looks backward, at the strength of the original detention finding, not forward, at whether custody is still worthwhile today. If a judge drifts into the wrong question, say so on the record and frame the issue correctly. But understand the flip side too. Because the reviewing court can examine the record for itself, a mislabeled inquiry will not win a reversal when the evidence for detention was there all along. The argument that wins is the one that goes to the substance, that the state's original showing was not enough. So, here is the thread that ties this week together. Every one of these cases lives in the same narrow, high-stakes window, the days after arrest and before trial, under the Pretrial Fairness Act, when a court decides whether a person waits for trial free or in a cell. In Ford, we saw the reach of the state's power to revoke release. A new charge from anywhere can start that process. In Talbert, we saw the gate a defendant must pass to test a detention order. A plain motion for relief will open it. And in Davis, we saw what that motion actually asks. Not whether custody still makes sense today, but whether the state's original case for detention held up. Taken together, they map the front end of a criminal case. The power to detain, the path to challenge it, and the true measure of that challenge. Thank you for watching this week's episode of the Illinois Appellate Roundup. If you are in need of appellate or post-conviction representation, please do not hesitate to call me directly at 312-5173-877. I'll see you next week.